Hey all. So this is a little share due to something that came out from the United States District Court for the Eastern District of Pennsylvania, which is my area, or one of my areas, one of my heavier areas. So it's kind of important for those people out here, but oftentimes what happens in one circuit is really applicable everywhere in any event. So while it's an interpretation by one set over here, they all pay attention, and it often reflects the general consensus across the country for various circuits. Just to remind you, and by the way, this has to do with your pain that you suffer, that you are alleging causes you to not be able to work. So we'll get into it in a second, but just so you know where this comes into play, these kind of decisions, when you get through initial recon, ALJ hearing, all denied, you go to the appeals council. If you get denied there, you can then appeal to district court. That's federal district court. Every area's got one. And they look at only what's down below. So appealing to federal district court, while it's arduous, and the colleagues of mine that do it are very focused specifically on technical appellate issues. They don't take a case just because the person deserves to win. There has to be appellate error in there, because the appeals they do, they're not charging you for. So they're not going to take a case just because it's a feel good, let's drag it out longer business. It's only going to be because it's very, very good chance of getting a remand or a reversal. So there are few and far between, I think, that take cases, but it's good to know a few of them so that you can at least ask them to take a look if you get denied by appeals counsel. And don't wait. Don't wait until you've been sitting on that denial for a month, because any federal district court appellate attorney is going to have to file generally the notice of appeal within 60 days, and shortly thereafter a brief. And they're going to need paperwork from you before they're even going to consider it, including your ALJ decision, any AC appeals council brief, any ALJ brief, the appeals council denial, all that stuff, and possibly more. They might want your entire file that the ALJ had. So you want to have the names of people. Do your due diligence now. Find out who would be a federal district court appellate attorney you might go to ask them to look at it and see if it's worthy of appeal before you actually get a denial. I kind of think it's a little pre-planning that you might want. And then you'll have it. So the day you get denied, you can contact them and then shoot them up. You have everything ready to go. Okay. So this particular case, and I'm going to keep it really, really general, so we keep it short, but it had to do with a pain case. And while it may have had to do with like a particular limb that was causing severe pain, the court did note that it is critical for ALJs in general to document how or why they do not fully embrace someone's subjective complaints of pain. So they do have to address it, particularly if they're not going to go with it, or perhaps if they are going to go with it. But as you know, the foundational basis of any kind of SSD, SSI disability claim is the medical evidence. And I can't emphasize it enough that subjective complaints of pain, such as that which you describe on your application or your function report or in your testimony, are not medical evidence themselves. Now, if they are complained of to your medical providers, and the medical provider says that you have been complaining of pain, it still remains, it's good that it's in the medical record. It would be a lot less effective if it were not in the medical record and you're just claiming it on your own and there's no mention of pain when you go to your doctors. Nonetheless, it's still subjective pain complaints. So you really want to, if you have severe pain, in addition to obviously having the type of impairments that would arguably cause that kind of level of pain. And this is compared to more mild pain that we all work with, kind of the little aches and pains and periodic exacerbations. So, you want your medical records to reflect all the diagnostics that would point to that particular pain. Okay, not just that the impairment might cause pain, but that there are diagnostics pointing to that area as well, if that's available. If it's the kind of pain that is severe, in all likelihood, it's affecting your concentration, your ability to focus, probably your mood, because when we're in severe pain, I'm actually antisocial. You know what I mean? Like, I'm not talking to anybody, and I'm just going to mumble grumble, in private, and handle it that way, because I'm just not a sociable person when I'm not feeling well. And particularly if I was in severe pain, I'd probably be crying. So if that is the case, most people, when they're having difficulty, I shouldn't say most people, I should say many people who are having difficulty coping with the effects of severe chronic pain on their life will go and see a professional. There are mental health professionals that deal specifically with chronic pain effects on the psyche, okay? And help, I don't know if teaching is the right word, but helping people learn how to develop stronger coping skills and different ways to handle it, so they're not suffering so much from the mental aspects of the pain. The pain itself is bad enough, right? So another colleague had mentioned that one thing he recommends, and I recommend this also every single time, so let's put it out there. If you're not seeing a therapist for quality of life changes due to that severe and chronic pain, it could be relationship, but it's like if you're so grumpy with your very bad pain that it's affecting your relationships, that is something also people will sometimes speak with. Usually it's all of these things together, but maybe consider starting that kind of counseling, because then there's going to be documentation of how your chronic pain is so severe as per you. So it's still subjective speak, but you're actually going to get the repercussions of that addressed, the kind that normally wouldn't be in a diagnostic test, right? It's those outlying effects that pain has on us. So in the records and at your sessions, you're going to describe exactly what happens. And if it's that, again, chronic pain, severe pain, we can't concentrate when we're going through it. Ask anyone with a migraine impairment. When they're in a migraine, they are not able to think straight. In fact, they have to lie in the dark. So you can hardly, arguably, you wouldn't be able to do even the most simplest of jobs with a simple 1-2 step, instructions that you have to do to accomplish it. Repetitive, simple. I call it sometimes fifth grade, something that you don't have to be ever trained previously. You don't have to have an education. You don't have to have graduated high school. You don't even have to have graduated middle school. So, they look at those jobs too, guys. So when you are talking about this chronic pain that is, arguably subjective, consider whether you're having these, the functioning in our cognitive and mental arena interrupted by your pain. And let's say you have bad pain for 2 hours a day until your Percocets kick in, then that would be 2 hours a day that you can't function due to pain, or at all, like not even the 1-2 step, follow the instructions, because the pain is so bad. And then of course, with the Percocet, you can do the physical 1-2 step, but maybe, maybe not so fast. But anyway, the point being, you need to back up everything with professional attention. Subjective complaints don't hold much water. And this particular circuit court opinion it upheld the denial after saying an ALJ always has to substantiate, his determinations on someone's pain in his decision. But they went on to say, because this individual didn't have medical evidence that vastly supported the subjective pain level she was describing, excuse me, then she, it was insufficient. They can't presume it to be just because she says it, or else everybody would win their case because they would just say it, right? So one more thing to consider when it's a chronic pain situation. We make the mistake of thinking because we're sincere in what we're complaining about, that therefore, why wouldn't someone believe us? It's not that the person doesn't believe you. They can't rule on that basis. And if there's nothing substantial in the medical record that they can cite to, they will be overturned. So it's not the judge being mean or not believing you. That's not it at all. It's just that it's got to be medically founded. And this is another way to get it medically founded. On top of the actual physical medicine being there, the proof of the impairment, the objective ways that pain can perhaps show up. And we can go into that in a different video. But right now, the mental health is what I wanted to drive home. And it's not that there's a sickness, per se, but it is a mentally functionally limiting impairment, the physical one. It's where it crosses over into the mental and affects it, even though you don't necessarily have some previous mental disorder, right? Usually it comes under the arena of adjustment disorder, or anxiety is often another one. And whether you want to say it's anxiety from the pain, or the quality of life changes, or the fact that you can't pay your bills anymore, those are all things that can lead to, reasonably so, reduced concentration and focus. Pain, on the other hand, can actually reduce you to not being able to move for 2 hours till pain meds kick in. And that would be, pretty substantial amount of time to be off of work, that I think if it is taken as such, a decision maker would award, because you can't get out of work 2 hours a day to go lay down with Percocet. You can't, and wait for them to kick in. So anyway, get those things well documented. Mental health providers can be a fabulous way to not only get that done, but also to learn some of those coping skills. So maybe you can at least adjust better to this change in the quality of your life, and mentally getting through the pain, because I think that can help. It's not going to change the physical pain, although it might. That's a whole nother thing. But, aside from that, the evidence is what you need as to how that pain is affecting you. And it would lend itself to how severe the pain is then. Okay. All right. That's it, guys. Third Circuit Court opinion. Talk to you later. Bye.